Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded, so please stay behind the podium and keep your voices up. Please also introduce yourselves. Should it be applicable, you should not use the names of children, minors, or victims during the argument. And you can refer to people in those instances by their initials or generic terms like the child. The judges have read your briefs and are ready to proceed when you are. And would you like to reserve any time?
Your Honor, I think I'll reserve 5 minutes. I don't really think we're going to get close to the whole 15 with this type of an argument, though.
Very well. You may proceed when you're ready.
Thank you, Your Honor. My name is John Johnson, Jr. I represent Paul Hawkins. As you know from reading the briefs, this case involved 2 counts of sexual imposition. The alleged incident or incidents occurred in October of 2015. The trial, for COVID reasons and other issues, did not actually occur until April of 2021. But the reason we are here is because it's our contention that the judge erred by overruling the defense motion for a judgment of acquittal at the close of the state's case and at the close of all of the evidence. And the reason we say that is because Section 21AP0016 carries with it a...
Counsel, could you just step over a little bit towards the podium, just because we're recording this?
Oh,
thank you.
yes, ma'am. 21AP0016 carries with it what's been, I guess, colloquially called the corroboration requirement. And in this case, it's our position that there was no corroborating evidence to support the alleged victim's version of what occurred. In fact, when you read through the transcript, the only person who the state was using as a corroborating witness was one who was a friend of the alleged victim during high school, whenever this supposedly occurred. And testimony contradicted and was inconsistent with the alleged victim's testimony of that evening.
And that's what I was going to ask you, because you focus in on the contradictions and say, therefore, it's not corroboration, but he also testified that he saw your client with his hand on her thigh while he was in the car as well. So how is that not corroboration?
Because she denied that happened. The alleged victim specifically was asked on cross-examination about that, and she denied that Paul had his hand on her thigh in the car and was in the car. I mean, that's about as contradictory as you can get. And therefore, what I'm saying is you can't rely on Paul as a corroborated witness whenever the victim herself says, no, that didn't happen.
But would that go more to weight?
I don't think so. I mean, if you're using this person to corroborate the victim's version of what happened and the victim says that did not happen, I don't see how that can be corroborating of anything. And going down those same lines, again, talking about contradictions and inconsistencies, the other major component that creates a problem for the state is the description of the vehicle itself. They had completely differing descriptions of the vehicle. Described this as a dark-colored SUV. The alleged victim says, no, that's not what this vehicle was. In fact, she described the vehicle first at trial as a sporty, silver-colored car with an automatic transmission. She had told the CAC previously that this was a gray sporty car with a blue stripe. And she denied that it was a dark-colored SUV in any event. She then, at trial, for the first time, said that the actual offense occurred in a white Jeep later on in the evening. She's the only person who described that vehicle as a white Jeep. The only other person, again, was a dark-colored SUV, which she denied. You can't use Holden as a corroborated witness if what he is saying is denied by doesn't make sense. And
Counsel, are you, is it your position, your client's position that there were only inconsistencies, that there was no corroboration presented by?
well, they both agreed, the alleged victim, that they were in a car driven by Paul Hawkins. So that is consistent. The trouble is, they couldn't agree on what car that it was that they were in. I mean,
That's what I was getting at with my first question, I guess, and that is, what is corroboration? Is it, because you said, well, the victim denied it, but yet at the same rate, the victim did say this happened. She's just telling under different circumstances, whereas saying, no, I saw it happen under these circumstances. Then isn't the jury allowed to then weigh it because you have a victim and a corroborating witness saying they both saw the assault?
except what he said he saw, okay? That was not what the offenses were about. The offenses were about what supposedly happened later in the evening, whenever the alleged victim said that she was alone with Paul Hawkins in this white Jeep driving around out in the country. Simply because he saw something that the victim denies he could have seen because it didn't happen earlier in the evening does not make him somehow corroborative of whatever the offense was later on in a different vehicle in a different location. So that's where I'm going with this corroboration argument. I mean, otherwise you've got a situation, I suppose, where you could say, well, she lived in Worcester, Ohio. She said she lived in Worcester, Ohio, and Paul Hawkins lived in Worcester, Ohio, and therefore that's somehow evidence of corroboration of something that occurred somewhere else. I mean, to me, that's...
Well, nonetheless, you do have him testifying as well as the victim that they both were in the car and were being driven home by your client, the defendant.
That part is consistent.
Okay, so that is corroboration, at least that they were in the car together and that he had access to her. What I'm asking is because didn't he say, I never drove her home?
My client, absolutely. He said that, and so did his wife. They both testified to that. So, talking again about this idea of corroboration, to me, at least, it would seem to be a requirement that there be some consistency between what a corroborating witness is being asked to testify about and what he is supposed to be corroborating, as explained or testified to by the alleged victim. And that is missing in this case. At least that's our position. And without that, the court should have granted the Rule 29 motion for judgment of acquittal. Where am I at on time?
You are at 7 minutes and 20 seconds.
Okay. The balance of the argument in the brief talks about manifest weight of the evidence. And, I understand that that's a very difficult road to hoe for a person in my position, arguing that the jury's verdict was against the manifest weight of the evidence. However, again, it's kind of like arguing in a closing argument that if you look at all of the evidence that was provided by the state and then weigh that and say to yourselves, well, there's no way a reasonable jury could have come to a conclusion that this man is guilty, that the case was proven beyond a reasonable doubt. And that's what I'm asking you to do. And the basis for that is, again, looking at the inconsistencies throughout the case on part of the state's own witnesses. We're talking about different descriptions of the vehicle, different descriptions of when this all supposedly happened. The detective testified that the alleged victim told him that it occurred in a sporty blue Saturn Ion that had a manual transmission. At trial, she said, no, it happened in a white Jeep with an automatic transmission. I don't know how to drive a manual. I mean, those are pretty significant inconsistencies when we're talking about how do you get past the idea of proof beyond a reasonable doubt. And if you look at each of those inconsistencies, going right down the list, as I've tried to do in this brief, the conclusion that you reach is that the verdict was against the manifest weight and that the jury clearly lost its way in convicting Paul. Thank you.
Thank you, counsel. You will have your full 5 minutes for rebuttal.
Okay, thanks.
May it please the court. My name is Dylan Colby and I represent the state of Ohio, the appellee in this matter. I'd like to first begin by addressing the appellant's first assignment of error. A challenge to a denial of a Rule 29 motion for judgment of acquittal is a challenge to the legal sufficiency of the evidence presented at trial and whether the state has met its burden of production. It's well established that in determining whether the evidence at trial was sufficient to sustain a conviction, an appellate court must view the evidence in a light most favorable to the prosecution, and the relevant inquiry is whether, after viewing the evidence in such a light, any rational trier of fact could find the elements of the crime proven beyond a reasonable doubt.
Well, he's saying that in this particular offense, that you have to have corroborating evidence.
Correct.
So what did the state present as corroborating evidence?
So the state did put on testimony of, I will call him, rather than his full name, I'll call him HJ. This minor testified that on the day in question, he was with the victim, the appellant, and two other minors, all riding in the appellant's car. They were going to get supplies to build homecoming floats. This corroborates the victim's own testimony, who stated that on that same day, she, HJ, some other minors were in the car with the appellant going to get homecoming float supplies, and it even contradicts the defendant, or the appellant rather, his own testimony that he was never in the car with any minor, and that it was specifically the policy of him and his wife that he was not to drive around any high school kids for fear of false allegations.
Counsel, let me stop you. Did the other two minors, they didn't testify then? The only one was HJ?
The other two minors in the car did not testify. However, there was testimony from another minor whose house the float building activities took place at. So her name was, I believe,
That's okay.
SH, I believe her name was. So SH testified at trial that on the day in question, the appellant, the victim, the two other minors from the car, all were at SH's house to build homecoming floats for the dance. The appellant's wife testified in his defense, and even she testified at trial that the appellant was present at SH's house on the day in question to build homecoming floats.
Well, I don't think he's denying that, is he?
He's not denying the
Being
fact
at the
that
house.
he was at the house, but he's denying the story that he gave them a ride to the house.
Mm-hmm.
But I believe that the testimony from SH that everyone was at her house, that HJ testified that it was the appellant who gave them all a ride to the house, and that the victim also testified to that fact, is corroborating evidence, especially in light of the fact that the appellant himself denied ever being in a car with minors.
Do the details about the vehicle matter?
In my opinion, they do not. They are slight inconsistencies. However, it's a jury's job, I would submit, to weigh the credibility of witnesses and determine the significance of any inconsistencies in testimony.
But those are not just minor inconsistencies. I mean, they sound pretty major to me. I mean, one thing if it was a blue car and they said it was gray, but they're talking about a sporty car versus a white Jeep. That's not even close.
So I believe that the discrepancy there comes from the fact that after building the floats, they went home to the appellant's house and then switched cars. So I think the victim was under the impression that they had switched to the appellant's wife's Jeep, and that that's where the assault took place in.
So the testimony you're saying is that all the minors were in two cars.
That's correct.
Thank you.
I would also like to point out that the contradiction originally was between whether there was a gray or a silver color to the appellant's car, and that I think after a couple of years, a gray versus silver distinction, while it still is not matching the blue color of the appellant's actual vehicle, the gray versus silver distinction to me just does not carry much weight. I would also like to point out that just overall, this corroboration requirement is a low bar to meet. State versus Economo, the Supreme Court noted that the corroborating evidence does not have to allege facts that themselves would meet some or all the elements of the crime. Rather, any slight circumstances or evidence that would merely support the victim's own testimony are enough. And in Economo, the appellant had abused his victim, and the victim testified at trial to that effect. The victim's medical records were what were used as corroborating evidence, and those records confirmed that the victim did indeed have an appointment with the appellant on the day that the abuse took place. The Supreme Court upheld the appellant's conviction on the grounds that the medical records constituted sufficient corroboration, even though those records by themselves would not be enough to support a conviction. So in this case, the victim testified that when she was 14 years old, the appellant rubbed the victim's vagina on the outside of her clothing. The appellant would have been roughly 55 years old at the time, and this testimony, if believed, is sufficient to sustain a conviction for sexual imposition. The testimony that surrounded the victim's own testimony placed the appellant in the car with minors on the day in question, despite the appellant's denials of ever being in the vehicle with minors. And furthermore, the appellant's own statements to Detective Berkey of the Wayne County Sheriff's Office were admitted, and he denied to Detective Berkey ever being in the presence of minors. So we have two separate statements years apart where the appellant specifically denies ever giving any of these kids a ride anywhere. And this isn't even the only corroborating evidence that the state has produced. The victim's mother testified that 4 months after the incident, she actually approached the victim and asked if the victim had ever been inappropriately touched. The victim was reluctant at first, but then admitted that she had indeed been fondled in this way by the appellant 4 months earlier, and she begged her mother not to let this information get out because she did not want to be bullied or have anybody look at her differently.
Was that admitted without objection?
That was admitted without objection. So the Economo Court established that one way to satisfy the corroboration requirement is reasonably prompt reporting of the incident to friends, family, or police. However, reasonably prompt has never been defined. State versus Bresci held that a 2-week waiting period for a wife to tell her husband about her abuse was sufficient. However, we're not dealing with an adult in this case, we're dealing with a 14-year-old child, and I would submit to you that waiting 4 months to report, especially when she wasn't even the one to instigate this reporting, that coupled with her youthfulness and her clear fear and intimidation at what had been done to her, is reasonably prompt. And then finally, this court in State versus Betts in 2020 gave a couple examples of what evidence would be sufficient to sustain a conviction under the corroboration requirement. And one example was testimony from a third-party witness that a criminal defendant was behaving in a weird manner around the time of the incident. And we heard testimony in this case from J.H. that the appellant, a fully grown man in his 50s, a teacher at the victim's school, and the father of one of the victim's friends, called the victim pretty lady in front of other high school students and then stroked her on the leg with his hand. Now, Detective Berkey also testified that when he spoke to the appellant regarding these allegations, the appellant appeared nervous and he appeared to be avoiding law enforcement. And if none of this behavior rises to the level of weird, then I don't really know what does. Under Ohio case law, the state did present more than enough evidence to corroborate the victim's testimony regarding the sexual assault she suffered in October 2015. What time am I right now?
You have about 2 minutes left.
So for the second assignment of error, a manifest weight challenge, this is, as we know, a high bar for defense to meet. Verdict will not be disturbed on appeal unless reasonable minds could not reach the conclusion reached by the trier of fact. And as we've gone over, there were some inconsistencies in the testimony regarding what the color of the car was that the minors rode in on the day in question, whether the appellant switched cars to a Jeep from his original Saturn Ion, or whether the assault took place in the Saturn Ion. But to me, these inconsistencies are just matters for the jury to weigh. And when you consider the fact that the defense, or the appellant rather, presented their own inconsistencies in testimony, this was a jury question, and we cannot say that the jury clearly lost its way. The defense presented contradictory testimony in the sense that the policy of not driving children around was, according to the appellant, instituted when he first became a teacher in 2011, but the appellant's own wife testified that this policy came into effect when the Me Too movement became popular, which would have been in 2015, perhaps even 2017. The appellant's own statements to police and at trial were inconsistent as well. When you consider the wife's testimony that the appellant was indeed at the house, the appellant was in the car with the minors, according to the testimony from HJ and from the victim herself. There were small inconsistencies, like I said, but we heard testimony consistent that the pretty girl was to sit up front. A corroborating witness said this, despite the fact the appellant denied this ever happening. The appellate court here must give deference to the credibility determination made by the trier of fact, and these are just the type of credibility issues that the jury is meant to weigh, and that's what the jury did. The jury did its job, and a conviction is not against the manifest weight of the evidence just because a trier chose to credit the state's version of events. And for those reasons, the second assignment of error should also be overruled, and the conviction should be affirmed.
Thank you, counsel. Thank you very much. And counsel, you will have 5 minutes for rebuttal.
Thank you, Your Honor. Just a couple of points, and these are more factual things than anything else, but first, with respect to the detective's testimony, I heard the assistant prosecutor say that the detective felt that Paul was trying to avoid him, which was something that was weird or unusual behavior. The fact of the matter is the detective testified that he did not feel that Paul was trying to avoid him. He testified to that on a recross-examination at the beginning of the defense case. I recalled him for that purpose because the judge, in deciding the Rule 29 motion, made a reference that the detective thought he was avoiding, Mr. Hawkins was avoiding calling him back. When I called him on recross, the detective said, no, I did not think Paul was avoiding me, and I told Paul I did not think he was avoiding me. So that's another example, I think, of stretching to reach this corroboration requirement. The other thing I noticed that I think it was Judge Carr asked the assistant prosecutor about was C.S.'s mother, the statement that the mother testified about. Well, in the first place, the mother did not testify in any detail about what C.S. was saying had occurred. And second, what the mother testified to was simply that C.S. said X, not any detail or anything that would be consistent with what C.S. testified to at trial, except the general, C.S. told me Paul touched her, or something to that effect. I was checking in the transcript before I jumped back up here. Again, given the time frame, the period between the alleged incident, which supposedly happened in October of 2015, and this supposed disclosure that happened at the end of January or early February of 2016, these are not contemporaneous disclosures, as this court has previously noted in other cases, as corroborative. This is not the same situation. And the reason that's important is because that puts us right back into who was the corroborating witness question. And the only person that the state has relied on, again, is this Holden Jackson. I'm using his name because he was 18 or older at the time of the trial. And for the exact same reasons I argued previously, Mr. Jackson's testimony does not provide corroboration sufficient to get by that Rule 29 or to satisfy the requirements of 21AP0016B. For that reason, Your Honors, we ask that you reverse the trial court's decision and enter a finding of not guilty on the first assignment of error. And if you determine that the verdict was against the manifest way of the evidence, we ask that you reverse and return this case for a new trial. Thank you.
Thank you very much, counsel. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. The court is now adjourned.